Jack Smith, Trump prosecutor, wants a very speedy trial, filed a motion with the DC court telling them that we can get this thing done quickly and that America needs to get it done quickly because we got such a public interest in seeing Trump prosecuted. Now, we long suspected that they wanted this done in this fashion because it's electoral interference. It's them waging their campaign against their political enemy. They know Joe Biden is hardly competent, so this is the only thing that they can do. They're moving pieces around. There's no coincidence that we've got 4 different indictments that are percolating all right now. They all launched at the same time, just like you move pieces around on the chessboard. So today, we're talking about timing and speedy trial rules, and I know it might sound boring, but it's actually pretty simple and it's quite important because they're trying to nestle this thing in right before the end of the year. In December, when jury selection is when they want to have this all start. And so today, let's go through this various paperwork filed from the court, and we're starting with Trump's filing because he's asking for something that is sometimes unusual in a criminal case. Oftentimes, people think of the defendant, the person who's been charged with the crime, as the person who wants to exercise their right to a speedy trial. Because if a defendant is sitting around in custody, you can think about the Count of Monte Cristo when Edmond Dantes is locked away forever and there's no speedy trial for years and years and years. And that's his name, right? It is Edmond Dantes. So he is locked away forever. And then that turns into a violation of his due process. And so we want to say we can't allow that to happen in this country. So we're going to make sure that it happens quickly, right? Trial happens within a certain period of time so you're not locked away in a dungeon for 400 years. So they say that the defendant wants to exercise that right. But sometimes the defendant can waive that right. Sometimes the defendant can exclude that time. So let's say if you've got 70 days to bring a trial, the defense can say, okay, yeah, I want my 70 days. I want my trial in 70 days. Why? Because the defense might be able to say, well, they're not going to have all their evidence in 70 days. They're not going to have their blood results or their DNA evidence or their witnesses are not going to be available. And so there's a tactical strategy as to why a defendant would want their trial to go quickly. But there's often other times when the defendant doesn't want that time. They say, no, we don't care about 70 days. Well, make it 270 days for all we care. And in criminal law, we're always calculating the days. That's why you always have an end of trial date so we can calculate the time between the arraignment, the initial court date, and the time between the trial. We want to literally count the days. How many days? 1, 2, 3, 4, 5. It gets a little complicated. So this is Donald Trump now saying, we want to exclude time. Okay, don't count this against us. We're perfectly happy just sitting here charged as a defendant. We're not trying to go quickly here. And so this is from Trump's lawyer, short filing. This is submitted by John Lauro, and it is telling us the following. It is the motion to exclude the time. So in other words, we're not counting the time against us. And they want 25 days to go. The time between the initial appearance and August 28th, which is the first status conference, which we haven't even hit yet, says, please exclude that. This is Trump's lawyer. Why? They say it's warranted. This is a very complicated case. The complexity of this matter. There's also a substantial volume of discovery. We also have novel questions of facts and law. No kidding. Never happened before. President Trump, they say, is charged with 4 counts. Wrongfully alleging conspiracies spanning months involving hundreds of potential witnesses across the country. The prosecution states that this case will, quote, involve a substantial amount of discovery. But additionally, Trump's lawyers say this matter raises significant constitutional issues and other novel questions of law. We anticipate reviewing terabytes of data and hundreds of thousands of pages of hard copy documents. We intend to file numerous critical motions. We're going to interview hundreds of witnesses. We're going to issue dozens of Rule 17 subpoenas, and we're going to retain expert witnesses, etc. That's a lot of work. So they say under the law, a court can exclude periods of delay from the 70-day window under the law, the Speedy Trial Act, which a criminal trial must commence. And some of the reasons why the judge can exclude that time is the following. Whether the case is so unusual or so complex due to the nature of the prosecution or the existence of novel questions of law that it is unreasonable to expect adequate preparation for pretrial proceedings within the time limits established by this section. So, is this so unusual or complex? Does this bring in new novel questions of law that 70 days, or let's say December, would cause this to be inadequate, unreasonable to expect Trump's team to be prepared? Obviously. I mean, they've spent years since January 6th, and Merrick Garland has come out and said, this is the most extensive investigation the DOJ has ever done. Really? You got 1,000 riot charges, and half of those have already pled out. Many of those are nonviolent. Most of them are nonviolent, the vast majority. Okay. Here, the sheer number of witnesses, this is Trump's team speaking, and the volume of discovery alone, it warrants a continuance. So we get more time and the time doesn't count. To say nothing about the issues of first impression that we're going to have to brief, okay? Never had a president before, never had charges like this against somebody who's running for office, who was the president, who was in a position of power to ask his people to investigate certain things. Where are the bounds between free speech and criminal action that they're just making up? All of these are going to be new and novel. Never been a case like this before that we can compare it to. For a case of this magnitude, Trump's lawyer prosecutors say it would be impossible for the defense to evaluate the government's evidence, prepare its own defense, and participate in pretrial proceedings all within the time constraints that are in place here. And so accordingly, the ends of justice would be served by the exclusion of the 25-day period from the Speedy Trial Act calculation. So we know we've got 70 days, so just delete, and we know it's been here from August 3rd all the way till August 28th. Just subtract 25 days from our 75. Or in other words, exclude that from the calculation. Don't hold those 25 days against the 70. They don't count on the clock. So Lauro says, the prosecution requested that we include this when we file this. They said, hey, make sure you tell the judge this. And they filed it in an email, probably snarky as heck. Says the government's position is that the ends of justice are best served by a speedy trial. This is your prosecutor speaking. The government will respond more specifically once we've reviewed the motion. So they said, all right, we'll copy and paste that and throw that in there. And then they signed off on it, sent it in, counsel for President Donald Trump. So that gets sent over, and it makes sense, okay? From our perspective, as a defendant, you go, yeah, how many dozens, if not hundreds of lawyers did they put on this case? Terabytes of data, hundreds of thousands of pages of documents. We want at least as much time as they got. And let's not forget that the government has exponentially more resources than the defense ever will, ever. They've got the entire DOJ, the entire FBI, dozens of US attorneys, if not hundreds of them, working on this day and night. We saw in previous filing that you've got these attorneys who are sitting there on Saturdays and Sundays, just scraping over Trump's True Social posts to see if he might offend them. And so that was the original filing, the motion to exclude time. But the government doesn't want that to happen really at all. In fact, they want this trial to happen immediately. They want all the time included. And so they responded as follows. This one's 8 pages. They say, all right, this is the government's response to a prior minute order. They say, hey, judge, you know, you asked us before to file a brief telling you about a proposed trial date. Here's what we've got. They say the government proposes that trial begin on January 2nd, 2024. So that's what they say their trial date is. Trial begin on January 2nd, 2024. And they say that from that date, it's going to take no longer than 4 to 6 weeks. And I believe we've got at least Iowa primaries very early. So Iowa's, I believe, in January, and then we've got some other primaries right after that. But the reason I say this would start in December is because I've already seen this date, which is where in December, they're going to pick the jury. And as we know here, once the jury is impaneled and sworn, that's when jeopardy attaches in a criminal trial. So unless the jury is sworn in on this date, I'm imagining that they pick the jury, get them sworn, get them impaneled, then give them the break for the holidays, and then they come back for the actual trial in January. So I think what they're trying to do is be very sneaky here, personally. Oh, the trial starts in January. Not really. You've got to start picking your jury. You're doing your voir dire. You've got all of your, stuff prepped. You know basically where you're going. Of course, you'll continue to prep between December and January. In trial, you're prepping the day after the trial, the night after, the morning of, and all the stuff. So very curious that they're doing it this way. But if they pick the jury, they swear the jury in, and then they give them a break, that's when I would catch the start date. This stuff is starting very quickly. So they say, this is why they need it. They say this trial date and the proposed schedule outlined below would give the defendant, Trump, time to review the discovery in this case and prepare a defense, and it would allow the court and the parties to fully litigate any pretrial issues. The prosecutors say, most importantly, a January 2nd trial date would vindicate the public's, that's apparently us, our strong interest in a speedy trial. Do you want a speedy trial? We have a strong interest in this? They're speaking for us. This is our government. An interest guaranteed by the Constitution and federal law in all cases, but of particular significance here. Why? Because Trump, a former president, is charged with conspiring to overturn the legitimate result of the 2020 presidential election, obstruct the result, and discount citizens' legitimate votes. So to me, this reads as though this case is a little bit special, right? This case is an aberration. They're making this claim that, there's other constitutional and federal case law that says we should move these things along quickly here, just in general. The public has a general interest in not having a slow, bureaucratic, incompetent government. I would agree with that. So they make that same argument here. Now, in practice, of course, we know how that actually works. But then they say it's actually not routine. So it is guaranteed in regular all cases, but this is a special case because it's a former president, which they acknowledge this is a big deal, and it's got some pretty serious charges. Wow. So that's their justification as to why it should go quickly, which enables the counterpoint, which that it should go slowly because it is such a big case. It is such a critical slate of issues. So the government says 4 to 6 weeks. They say to estimate a prompt trial date. It serves everybody's interest, like the public's interest and Trump's rights and abilities to prepare for the trial. The government outlines the following date. And let's come back to this because we're going to notice that this feels a lot simpler than some other schedules we've seen. So on September 25th, they tell us Rule 12, other dispositive motions to Rule 12 stuff. Rule 12, motions, hearings, motions in limine, which are the preliminary motions that you file to limit or preclude testimony or to stop people from testifying a certain way, then oppositions, then replies in support of motions in limine, and then final pretrial conference. So pretty quick schedule. Then we're into trial by January. Now, in the Florida case, in the Florida documents case, we went through the schedule in that matter, and we saw that it was a lot more complicated. Many additional pages. Why? Because there were classified documents. But I don't see any classified document stuff in this schedule. We'll return. The general schedule would give the defense almost 2 months. Wow, almost 2 months after the original indictment to file motions, raise legal issues, and not issues which raise legal issues, not issues of fact stemming from the review of the discovery. It would then provide roughly 5 months before the start of trial for the defense to review the discovery. The government expects to substantially complete in advance of August 28th. So substantially complete, but not even be done with. This schedule also proposes that the court set a certain start trial in January, regardless of when jury selection finishes in December, to avoid uncertainty and hardships for jurors during the winter holidays. Okay, so it sounds like they're going to be sworn in and impaneled in December, but then they're going to actually start their version of the trial, which is just, oral argument, opening arguments, back in January. The government's trial date, they say it vindicates the public interest. It says it represents an appropriately speedy trial. We've undertaken extensive efforts to prepare and organize the discovery that's going to assist Trump in his review of the materials. And they always make this point, and I absolutely can't stand it. Look, thank you, government, for your index. Thank you for labeling what you think is important to the defense. We've undertaken extensive efforts to prepare. We don't really give a rip about what you've done, your extensive efforts. Give us all the files, because we're going to look it over again. And yet they should be in folders, and they should be organized, right, in a way that is like, sometimes what they'll do is the opposite of this. Sometimes they'll just, like, they did this in the Proud Boys case, where they just dropped in like 50,000 pages of stuff, and he needed like 2 pages, and like, here's 50,000 pages. So they can do it the other way too, right? They can be vindictive about it. But then they go the other way, and they say that we've gone through extensive efforts, and so you don't get enough time because we've done the work for you. They try to play it both ways. And thanks for doing all the work for us, but that doesn't mean that you get to take away from our time because you said that you gave us a summary. Assuming that a protective order is entered, the government expects to have substantially completed the discovery by August 28th. Now, there's a classified documents problem here that they're just leaving out of this filing. And they're noting this. They're saying, hey, by the way, Judge, John Lauro, he's already preparing his defense. He talked about it when he was on CBS. They say it appears that the defense counsel is already planning which motions they're going to file. We haven't even given them discovery, and they're already going to file it anyways. So they don't actually need more time. See, he went on CBS. He said we're identifying and litigating a number of motions that we're going to bring First Amendment claims on, saying Trump is immune from being prosecuted. So they're saying, see, Judge, so that way just delete more time. They don't need it anyways. And this time will ensure that Trump gets a fair and speedy trial. So they give us some law here. They say that the Speedy Trial Act is meant to protect the defendant, but they say also it's to protect the public. The public has an interest in prompt criminal trials. Yeah, because we don't want citizens locked under improper prosecutions by political hacks. Consistent with the Speedy Trial Act, they've accorded significant weight to the public interest. And they say here, it's difficult to imagine a public interest stronger than this one, in which Donald Trump, the former president of the United States, is charged with 3 fake criminal conspiracies intended to undermine the federal government, obstruct the certification, and disenfranchise voters. The DC Circuit has said that there is a direct linkage between Trump and the events of January 6th. And the DC Circuit, so this court, okay, so the government, this is so gross. We live in such a bizarre timeline. It's like we're watching the Republic just crumble in front of us. The DC Circuit, so the government prosecutors are referencing back to the same court, and the court has already said, because this DC Circuit has been prosecuting the J6ers for years now, and they've been some of the most hyperbolic, dramatic whiners you've ever heard out of any proceeding ever. So other judges that they're referencing and citing to now, they say other judges have already described Trump as being a direct link between the attack on the Capitol. And they also described it as the single most deadly attack on the Capitol by domestic forces in the history of the United States. It's very dramatic. Very dramatic. By domestic forces. Okay. So trial in this case, they say, is clearly a matter of public importance. During the initial appearance, they say that Trump's lawyers argued that a principal reason for delaying this trial is so Trump can review the discovery. They say it's perplexing then that the defense has refused to accept the discovery that the government has ready, even though there's on an interim basis under the proposed protective order. Well, of course, they're not going to take it and just acquiesce to your protective order. They say you should just take it and then we'll litigate the protective order after the fact. And if you don't like the protective order, you can change it after the fact. And the defense is saying, no, we're not doing that. We're not going to start processing anything until we know what the terms are of processing the things. In any event, although there is a large amount of discovery in this case, including witness interviews, grand jury transcripts, evidence obtained through numerous sealed search warrants, the government has gone to great lengths to organize the materials for Trump to assist him in his review. So, Thank you for organizing it. You mean the corrupt Department of Justice, along with the FBI, that has been prosecuting this man since he came down the escalator in 2016? They put some sticky notes on the files or something, and now it's like all good? Wow, thank you. Well, it's alphabetical. Wow, you even have a plastic cover sheet on this one. Congratulations. Nobody cares, FBI. These efforts, or DOJ, the efforts include providing him a compilation of certain key evidence on which the indictment relies and identifying material potentially favorable to the defense. Oh, like exculpatory material, like you're supposed to do? Thanks for that. It's called Brady. Indeed, assuming that a protective order is entered, by the time of the court's hearing, the government expects that its production and discovery will be substantially complete, but not fully complete. The government would then continue to produce the discovery on a rolling basis, and they say, we're prepared at this moment to produce the majority of the discovery. As soon, Judge, as soon as you enter this protective order, we're going to give them everything, including the following: grand jury transcripts and associated exhibits, witness recordings, agent notes. Again, they don't want Trump to be able to talk about any of this. This is why they want the protective order in place before they give it to them. Trump wants to take all of it and say, hey, look what they've got. Look at this discovery, and start sharing some bits and pieces about this. And they want to be able to slap him on it when he talks about recordings or transcripts, search warrants, grand jury subpoenas, also unredacted materials from other government entities, including the January 6th fake illegally constituted select committee. And they don't want him to disclose any of that. That's why they're fighting over this protective order. The government went to great lengths to organize these materials in a user-friendly manner, prepare them in formats ready to be loaded into a document review platform, and they created detailed logs to guide the defendant's review, which is all stuff they should be doing as a matter of course anyways. They've already got evidence systems. This is all stuff they should be doing already. And they're saying that this justifies less time for Trump. See how dishonest they are? In a separate filing today, which we'll take a quick look at, the government is requesting that the court schedule a pretrial hearing for SIPA, the Classified Information Procedures Act. Why? So that the parties can discuss a parallel schedule with respect to the minimal amount of classified info that may be subject to discovery in this case. So they not only do they want a trial to start in December with jury selection, they also want this to proceed aggressively, quickly, with incomplete discovery that is substantially complete, that they can then work on a rolling basis. So Trump's hands are tied. He gets what he gets when they give it to him. And there's a parallel process for the classified document. So Trump really can't see much of anything. He gets this initial tranche, then the classified stuff, he's got to go through a parallel process. And as we know, with the Florida case, that's going to take a very long time. Judge already bumped that trial out to May of next year because of the classified documents problem. So they're still asking for December, but they want this sort of expedited Classified Information Procedures Act to also go quickly. So they're asking for an expedited scheduling while in a footnote notifying the court there's classified materials, because that means Trump's people are going to have to get clearances, just like they're doing in Florida. Government will move separately to provide the court ex parte and under seal, which means they're not notifying Trump's team and they're not telling any of us about it, a draft copy of the detailed production letter and the source logs that they're going to give the defense. The materials demonstrate the scope of the discovery that's readily available for review. They say the government's also going to provide a compilation of key evidence that supports charges in the indictment, including a detailed 45-page speaking indictment that provides a roadmap to the government's theories and identifies certain material within discovery that is arguably favorable to the defendant. Okay, great. Thank you for doing all of that. But we still get the same amount of time. You don't get to just subtract months off of our proceedings because you did some homework that you think is important. We think you're idiots because you brought this case in the first place. So we don't really think what your arguments are. We would imagine that you're going to provide us with a list of arguments, and in that list of arguments, you're going to have probably a list of rebuttal arguments. So we're going to come up with our own arguments. Thanks. The government stands ready to provide technical assistance or answer any questions. They say that Trump's lawyers have claimed, both in media interviews and initial hearings, that the government has been investigating this matter for 3.5 years. While the defense is starting with a blank slate, they dunk on this one a little bit. They say, not only is this claim impossible because January 2021 was only 2.5 years ago, but it's disingenuous. I think what they're probably arguing is that they went back in their investigation prior to 2021, January 6th. So you're being disingenuous here. You're misframing their argument. Typical. The defendant has been aware of and responded forcefully in opposition to certain information made public through the hearings, been aware of and responded forcefully in opposition to certain relevant information made public. I don't really know where this sentence goes. Furthermore, Trump and his counsel have long been aware of details of the government's investigation leading to his indictment. Okay. And they had first contact with the government in June 2022. At his initial appearance, Trump was accompanied by an attorney who was familiar, and he's got a greater understanding of this than most other defendants. He's got multiple lawyers, and they've been representing him for a long time. And so that's why this is a perfect time. It's going to afford Trump many months to review the discovery, raise pretrial issues, and prepare his defense. No additional time is even necessary or warranted under the Speedy Trial Act because because the public has a strong interest in it. Other courts have administered justice similarly. 5 months for co-defendant, 32 count co-defendant who blew up the World Trade Center, right? So Trump's like a World Trade Center bomber. 6 months between the arrest of that one. Nice. Yeah, sounds about right. In addition, over the past 2 years, courts in districts have managed a lot of cases. The fair and efficient administration of justice pales in comparison to other challenges. This number is so pathetic. It took them 2 years to process 1,000 cases. It's like a joke. 500 cases a year in a federal court for like trespassing and disorderly conduct crimes. It's all fake. This is all fake. These numbers are inconsequential. You can have a Super Bowl with 1,000 disorderly conduct-ish type of crimes in a Super Bowl weekend. Take a look at how many criminal felonies are prosecuted by a city government like New York City. How many felonies do they process in 1 year? Take a look at that number. See if it's more than 500 a year. See if it's more than 500 a year. You'll be surprised. It is. The fair and efficient administration of Trump's single criminal case pales in comparison to that challenge of 500 cases a year, most of which were nonviolent. So they say, conclusion, the government's proposed trial date represents an appropriate balance between Trump's right to prepare a defense and the public's strong interest in a speedy trial. Therefore, we should begin with jury selection in December. Signed by Molly Gaston. Now, as we know, they referenced very briefly that they have a classified documents issue, and they do. They submitted this simultaneously. They said, hey, by the way, we have a little bit of information. The government has identified a small amount of classified info that might be subject to discovery in this case. This is the DC case. So they just asked for an expedited trial schedule, and they're disclosing that we need a separate pretrial conference to discuss the SEPA procedures. They said because it's minimal, the process can and should run in parallel with the rest of the case. SEPA decides and sets values, a process for determining how this process goes. And so they say the government believes that we can efficiently address all of this. The minimal amount, and I don't know what it is, that's potentially at issue here, and the fact that one of the defendant's attorneys of records already possesses an interim clearance to review certain material, the government does not expect the disclosure to extend the pretrial schedule in this case. So they are disclosing more stuff that Trump can't see, and they want the judge to limit what he can talk about, and they want the trial to happen immediately, even though he can't get all of the evidence. And this is happening out of DC, and that means that the DC judge is probably going to grant a lot of this or tailor it in a way that supports them. Why? Because it is just the nature of this judge. Our friend Techno Fog over on Twitter at Techno Fog put together this great thread. He said, we look through the recent history of Judge Chutkan presides over this case. Our findings, he's treating Trump worse than other defendants, including a meth dealer. Well, they compared him to a World Trade Center bomber. They say this past week, Judge Chutkan gave Trump team 1 business day to respond to the protective order request. We talked about the local rules, which allow 14 days to respond, but she denied the extension. She said due process didn't apply to Trump. Here's a footnote. It says, without a doubt, the court's decision to vary from the default rules and allow Trump less than 1 business day to respond is concerning. Judge Chutkan set a hearing on August 11th, just 1 week after it was submitted. She denied Trump's request for a hearing where both lawyers could be present. And so we know that tomorrow we're going to be scheduled for a hearing on this protective order. In a prior case with a DC meth dealer, Judge Chutkan gave the meth dealer, which was probably not Hunter in this case, it was somebody named Jeremy, a 1-week deadline to respond to the protective order, and then set another hearing 2 weeks after it was submitted. Another one, a J6 defendant, got a 1-week response deadline and set the hearing out another week later. And so we see 2 different standards, one set of standards for other people and another set for Trump. And so Jack Smith is urging a very speedy trial for Trump. We're going to see what Judge Chutkan says and if this trial will stay on track as we continue to cover, my friends. And thank you for subscribing.